Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, good afternoon, my friends. Good afternoon. Today is Wednesday, August 13th, 2025, and we'll see what fresh hell awaits us today in the Aidan Kearney case, in the Commonwealth versus Aidan Kearney case in Norfolk Superior Court in front of Judge Doolin. We like Judge Doolin, don't we? Yes, I heard that it'll be maybe 2:15, maybe 2:30. That's okay. We have a lot of papers. Got some papers. Lindsey Gaetani filed a motion. We got a copy of that. We got Cosgrove's opposition. And we got a little reading to do, so we're gonna be just fine. I was wondering if there were any cameras in the courtroom because we, of course, have the Zoom, but as you know, the Zoom angles are not terribly flattering, and sometimes we can't even see the judge, and we often don't get to look at Tim Bradel. Although Mark Betterow, I think, is appearing by Zoom, so we'll get to see his cute face. But sometimes there's a camera in the courtroom, and then somebody will stream it live, like Boston 10 or Boston 25 or WCVB. So I don't know, but there are a lot of other cases on the calendar today for 2 o'clock. And so the as such delay on Aidan's case is not going to be such a big deal. Okay. All right. First up, let's take a look at Lindsey Gaetani's motion. I was looking at the docket, and it looks like Lindsey Gaetani is now representing herself. So she has been, as of July 22nd, she is pro se, which means she's representing herself. And someone named, an attorney by the name of Tanya Melisa Gravel, withdrew as private counsel for Lindsey Gaetani. So I don't know what's up about that. But she's now representing herself. And as such, she filed a motion to compel redaction of her cell phone extraction. Let's take a look at that real quick. And if anybody can tell me that there's a network streaming it, it's hard for me to watch the chat when I'm reading to you guys. So hopefully one of the mods will text me if anybody puts it in the chat that somebody is streaming it live on actual YouTube. So that'd be great. That'd be great. Oh, thanks. I got a blowout today. Thank you so much for appreciating it. Thank Jessica. Thank Jessica, who's the only one who's touched my hair for 20 years. Color and all. Thank you very much. All right. Moving on. Here's Lindsey Gaetani, Commonwealth versus Aidan Kearney. This is Lindsey Gaetani's motion to compel redaction of cell phone extraction, to limit access to extraction data, and to maintain current protective order. And this was filed yesterday. Today is the 13th. Yesterday was the 12th. Now comes Lindsey Gaetani, victim in docket number ending in 313, and witness other interested party in docket number ending in 43. Respectfully moves this honorable court to, it says also attachment C in the footnote, Order the Commonwealth to complete a redaction of Ms. Gaetani's cell phone extraction as reflected in the oral promise rendered to Ms. Gaetani by Special Prosecutor Ken Mello in December of 2023, and in spirit of the protective order issued by the Honorable Judge Krupp on December 27th of 2024. Wasn't that around the same time that Judge Krupp told them they had to turn everything over because they've been in possession of all the stuff that Aidan is still looking for since at least December of 2024? Oh, Ken Mello and his oral promises. We know they don't keep their promises. Number 2, deny any defense motions to unimpound or lift the protective order regarding Ms. Gaetani's cell phone extraction, whether in redacted or unredacted form. And 3, prohibit the defendant and his counsel from accessing the unredacted or redacted cell phone extraction at the Norfolk County District Attorney's Office, and instead appoint an independent third-party search team, because we should incur more expenses, to review allegedly inaccessible files, screen the phone in full, and provide only those files required under Rule 14, subject to the existing protective order. Well, catastrophe. I was thinking the exact same thing. She says, I don't want oral and Mello in the same sentence ever again. As grounds for this motion, Ms. Gaetani states the following. 1, background and protective order. On December 27, 2024, the Honorable Judge Krupp issued a protective order, attached as Exhibit A, concerning Ms. Gaetani's unredacted cell phone extraction due to the defendant, Aidan Kearney, disseminating private and privileged information from the extraction. Well, here's the thing. Tully is the one who released it to them. Tully's the one who gave it to them, isn't he? And it was like, it was like an extraction from, I don't know, at least a decade, right? The unredacted extraction was inadvertently, in quotes, provided by State Police Lieutenant, Brian Tully, to Defense Counsel Attorney Tim Bradle on April 24th of 2024. Mr. Bradle then shared it with the defendant, despite prosecutors invoking the clawback provisions of the Massachusetts discovery rules within 24 hours. Well, I don't think she wrote this herself, do you? Which one of the Twitter lawyers wrote this for her? It's well written. I'll give it that. Prior to Ms. Gaetani turning over her cell phone to Mr. Tully, Mr. Mello provided an oral promise that the contents of the phone would be screened by a reverse taint team, Mr. Mello's words. And Ms. Gaetani only signed a form provided by Mr. Tully upon that oral promise. Furthermore, Ms. Gaetani has made at least one written request for a copy of that form as signed in December of 2023 by Ms. Gaetani, but neither Mr. Tully nor anyone else has provided that document to Ms. Gaetani. So she didn't take a picture of it with her phone. Hot tip, anytime you sign a document, just take a picture of it with your phone so you have it in your phone. And you don't have to ask the person to give you a copy or find a Xerox machine. Thus, that document is not included in this pleading, despite the best efforts of Ms. Gaetani. In any event, the protective order was issued by this honorable court to prevent further privacy violations. Prior to Judge Krupp issuing that protective order, Ms. Gaetani obtained leave of the court to file pleadings on the docket. Quote, the court orders that Ms. Gaetani may file pleadings with the clerk's office. That was a Katie Rayburn order from Judge Katie Rayburn from 9/26/24. Ms. Gaetani then filed a letter with the court under impoundment in the weeks before Judge Krupp's order issued in December of 2024. 2. Defendant, or Roman 2, defendant's recent actions. On July 7th, 2025, during a hearing before the Honorable Judge Doolin, defense counsel filed motions seeking to either lift the protective order, unimpound the unredacted extraction, or obtain a redacted version of the extraction from the Commonwealth. Additionally, in a YouTube episode aired on July 8th of 2025, episode 790, Turtleboy's Day in Court, Karen Reed Cops Rehomed, The defendant discussed the contents of Ms. Gaetani's cell phone extraction, making inflammatory and misleading statements about its contents, further violating her privacy. Relevant transcript attached as Exhibit B. Roman 3, Ms. Gaetani's second letter. On March 28th of 2025, Ms. Gaetani submitted a letter to the court along with a motion to impound the document to the Norfolk Superior Court Criminal Clerk's Office. Ms. Gaetani provided 3 copies of this document to the clerk's office upon filing, but was informed that pursuant to the impoundment rules, only the clerk's office could send along the motion to impound, along with her letter, to counsels of record. 4. Proposed defense access to extraction. During the July 7th of 2025 hearing, defense counsel proposed a meeting at the Norfolk County District Attorney's Office with a, quote, tech team to review the unredacted extraction, including allegedly inaccessible files. Ms. Gaetani objects to this arrangement as the extraction contains highly sensitive, private, and privileged information, including communications with attorneys, medical information, and personal data unrelated to these cases spanning 15 years. Ms. Gaetani only became associated with the defendant in August of 2023, rendering most of the extraction irrelevant to these proceedings. Legal basis, Roman 5. Under Massachusetts Rule 14, discovery materials subject to a protective order must be handled in a manner that protects the rights of third parties. The unredacted extraction contains information outside the scope of permissible discovery and poses a significant risk of further privacy violations. Further, under this section, all automatic discovery obligations of items subject to a protective order are stayed until the issue can be resolved by the court. Hang on for 1 second. Talk amongst yourselves for a second. If you are on the Zoom, please mute yourself. Legal basis under Rule 14. Okay, where was I? The relevant sections of Rule 14, as explained in the reporter's notes to Rule 14, embody the principle that although Rule 14A provides for automatic mandatory disclosure or discovery, if danger or abuse can be shown or a privilege preventing disclosure applies, discovery need not be granted. The power of the court to restrict the scope of otherwise permissible discovery is recognized in the federal rule, the New Jersey rule, Florida rule, and the ABA standards, supra. Here, much of the material from Ms. Gaetani's phone is from the 13 years prior to Mr. Gaetani. Is there a Mr. Gaetani too? Oops, I think that's a typo. Prior to Mr. Gaetani meeting the defendant for the first time in the fall of 2023, the defendant has routinely disseminated material from the extraction both prior to and after the issuance of orders from this court, and further harm to Ms. Gaetani is imminent in the absence of judicial intervention. Indeed, as the reporter notes to Rule 14 explain, reporter's notes, did Grant write this? Quote, ordinarily, the party or person opposing discovery has the burden of showing why the discovery of requested materials must be denied or granted subject to restriction. But in certain cases, including some privileges, statutory or case law may provide the party seeking disclosure has the burden of proof. Statute or case law may provide that the party seeking disclosure has the burden of proof. Therefore, the 2004 revision added to this subdivision an explicit recognition that nothing in this provision shall be deemed to alter the allocation of the burden of proof with regard to the matter at issue, including privilege. Internal quotations omitted. Here, There are multiple examples of irrelevant, private, and privileged information, including but not limited to communications with attorneys, medical records, and personal photographs and videos. Thus, although automatic discovery of the material subject to the protective order is already stayed under Rule 14A6, Grant, Mike B from the 413 says, Grant asked stepmom, Wendy Murphy, to do it. Is that his stepmother or his biological mother? I thought it was his bio mom, Mike B from the 413. I don't know. Thanks for your super chat. Blah, 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 blah. The reporter's notes can say all of this stuff and things and stuff and things. And this is like 9 pages long. So let's just skip through a little bit. Since it is constitutionally permissible to limit pretrial discovery in criminal cases, there should be no objection to the Commonwealth giving material only to defendant's counsel in certain situations, which is preferable to denying discovery altogether. It is contemplated that this provision of Rule 14 will sometimes be used to prevent a defendant from seeing his own psychiatric report. In some instances, the mental well-being of the defendant could be adversely affected if he or she has access to such a report. Although the defendant in Moody had been convicted, the same rationale is applicable to the defendant awaiting trial. Letters to the manager, I have some concerns, says Kylie. Dude, where's my discovery? Under Rule 26, upon motion by a party or by the person from whom discovery is sought, and for good cause shown, we're still waiting for the host to start the meeting. But somebody's probably in the courtroom tattling anyway. So we'll see. The court may make any order which justice requires to protect the party or persons from annoyance, embarrassment, oppression, or undue burden or response. Further, secrecy is fine at the discovery stage before the material enters the judicial record. The court has inherited authority to protect victims and witnesses from harassment and undue invasion of privacy, as recognized in Commonwealth v. Fuller, 1996. Ms. Gaetani's right to privacy is further protected under General Law 258B, Crime Victim Bill of Rights, which affords victims dignity and protection from intimidation. Requested relief, Roman 6. Redaction. Ms. Gaetani requests that the court order the Commonwealth to promptly complete a full redaction of her cell phone extraction at the Commonwealth's time and expense by redacting all irrelevant, private, and privileged information, including but not limited to communications with attorneys, medical records, and personal photographs or video. Denial of defense motions. Ms. Gaetani requests that the court deny any defense motions to lift the protective order or unimpound the unredacted extraction, as such actions would exacerbate the harm to Ms. Gaetani already caused by prior disclosures at the hand of the defendant and in flagrant violation by the defendant of this court's orders. Independent review. I wonder if she's going to get up and argue this today, if she's pro se now and she has no attorney. That'd be interesting. To address the defense's claim of inaccessible files, Ms. Gaetani proposes that the court appoint an independent third-party search team or reverse taint team to review the extraction, identify any relevant and accessible files under Rule 14, and provide only those files to the defense subject to the protective order and any relevant redactions. This approach ensures compliance with discovery obligations while safeguarding Ms. Gaetani's privacy. When they turned over like more than 4,000 pages, last time, and or however many pages, 5,000 pages, and 4,000 were blank and hundreds more were redacted. I don't think that was her phone extraction. Wasn't that Tully's? I don't know. Someone posted in chat the hearing is only going to be audio today. Well, I'm in the Zoom room, and so I don't know. But we'll see. They said it's not going to happen until that Bradel was running late, and it's not going to happen until maybe 2:15 or 2:30 anyway. And also there's a lot of other cases on for 2 o'clock. So we'll get there. We'll get there. It was Tully's, right? So is she mistaken that what they just turned over? And last night he got more papers. He got more papers last night, right? They turned over a whole bunch of stuff last night, right? And Lori says it was heard, and if she's there, she'll have a camera shut off. Turtleboy said, it's time. It's time, but he got 4,000 pages last night. I mean, if we can get the audio, we'll get it. Somebody else said they heard court will be at 3. Well, unless you have like real information, not just rumor. We heard from Turtleboy that it was between it's going to be 2:15 or 2:30. And I've got the Zoom up, but they didn't start it yet. So there's that. Ongoing harm, Section 7. The defendant's ongoing and persistent public dissemination of information from the unredacted extraction, coupled with repeated motions to access it, has caused Ms. Gaetani significant emotional distress and trauma. Okay, what about the 60 days that he did in jail because of a setup? And because what may or may not have been a sonogram that wasn't exactly current. The court's intervention is necessary to prevent further harm and ensure compliance with its prior orders. Wherefore, Ms. Gaetani respectfully requests that this honorable court, A, order the Commonwealth at its time and expense to complete a full redaction of Ms. Gaetani's cell phone extraction. B, deny any defense motions to lift the protective order or unimpound the unredacted extraction. As Nurse Kim says, we're going to unimpound town. C, extend any existing protective order to also cover the redacted cell phone production if ordered by the court. D, prohibit the defendant and his counsel from accessing the unredacted extraction at the Norfolk County District Attorney's Office and instead appoint an independent third-party search team to review and provide only relevant accessible files under Rule 14, subject to protective order. And E, grant such other and further relief as this court deems just and proper. XOXO, Lindsey Gaetani. Dated August 11th. It was filed yesterday. We have a copy of it today. Okay. So there's that. All right. Who said audio only? Last night he said they were trying to move it to 3, but that is not the most current information because the reason is, and here's what I found out. Kelsey Fitzsimmons, remember Kelsey Fitzsimmons, the North Andover police officer who was suffering from postpartum psychosis, and a couple of North Andover cops that she has known for a very long time came to her house to take her baby away and serve her with a restraining order. And then she had apparently just gotten her guns back, and they knew that she had postpartum psychosis because she was out on medical leave from the police department, and they came to serve her with a restraining order from her baby daddy and take her baby away. And then they knew also that she had just gotten her guns back. And then apparently she took her gun out and she pointed it at herself, allegedly. And then her friend from the North Andover Police Department, another police officer who is a veteran of 20 years, shot her in the chest. And now she's being charged with felonies. Why didn't they tase her? They knew what they were walking into. Listen, anyway, there was a bit. So now that she's being held without bail, but she's still in the hospital because she's had at least 3 surgeries, maybe more. And she's still in the hospital recovering. And so today there was supposed to be a bail modification hearing, but it was moved to tomorrow. So whatever conflict Bradel had is now not a conflict because that hearing, it's a dangerousness hearing. That's going to be tomorrow at 2 p.m., which is the conflict because Walsh is also going to be tomorrow at 2 p.m. But when I went into the Zoom today to listen to the Kelsey Fitzsimmons hearing at noon, because that's when it was supposed to be, there's a big notice that you cannot record it. So I was just going to listen to it and then report back to you about what it is. This Zoom room today does not have that same warning. And so I also think that rule that that mean judge cited one day when she kicked everyone out of court and Young Jerks was streaming it and she threatened Mike with sanctions, remember? I have courtroom 25 I thought it was going to be in courtroom 25. That's on the docket, Suze, right? So there's that. So that was the reason why they wanted to move to 3, because Bradel had to be in Salem and then come to Dedham. But now he's just in Dedham, as far as I know. Yes. She was at the park that morning waiting for the baby daddy, not knowing that he was in court getting an ex parte. Right. And also, they're holding her without bail on those felony charges. Make it make sense. Why wasn't a mental health professional sent along? Why wasn't she tased? Did they have to shoot her in the chest? I have so many questions about that. Because she was at home. She was feeding her baby on the couch. She didn't have a vest on or anything. Thanks, Lou, for your super sticker from Australia. Thank you, Blessed Mom from Texas, for being with me for 15 months. XOXO. And thank you, Emmon, for being here for 9 months. Did Bev sign off Karen get her car and phone back? She did, John Jackson. She did. So she should be getting it back. Yes. Her baby daddy is a firefighter in that town and in North Andover. And also, we went over a lot of articles. Like there were 9 firefighters and or their wives who were pregnant at the same time that Kelsey was pregnant. And I have the Zoom feed up, but they haven't started it. Is anybody broadcasting it like on their channel, like on Boston 25 or Boston 10? Apparently there's a high water demand. We're supposed to not water our lawns here. And so I don't know if she got him back yet, but I heard she did. They took, actually, Cynthia, they took the baby away from her first, and then I believe they shot. And she released a statement. We read it. Tim Bradel's representing her. And Manja's late to the party, but you're always on my TV when I'm busy pet sitting. Hi, pets. Pets like me. Thank you, Mark. Mike from Providence says, have been on stream and all. Here it looks a little darker and it looks tremendous. Thank you. Thank you very much. I got a blowout today. Thank you to Jessica. There's a new Brian Walsh motion to dismiss, which I also have. Thank you, Mike. And thank you, Just Irish, for just saying that you appreciate me. I appreciate you even more. And each and every one of you that choose to spend your days with me. Let's take this down for a moment. Put this up. Is it audio only? Like I have to call in audio kind of thing? Because this is what's happening in the Zoom room. Except for it's not the way that I wanted to show it to you. So hold, please. So yeah. So whose camera is in the courtroom? Hold on. And if it's on YouTube, then it's okay because we can stop and rewind and start it when it starts and go back. But the problem is all right, Broken Baker has it on camera. That's great. Where is he getting it from? Hang on. Do, 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 do. Okay. All right. Let's see. I'm literally in courtroom 25. Is it a different Zoom? Oh, for the love of the traveling Mary. But it didn't start. It didn't start yet, right? They're in courtroom, main courtroom. Oh, for the Pete's sake. All right, that's a different Zoom room. Hold on. Hold, please. I've got that information too. How come they don't notify me when they do this? 161. No, that's session 2, room 25. Oh, for Pete's sake. Hold, please. Exit. I was so on it today. Thank you. Thanks, you guys. Got it. 178. Thank you, Scott, for sending me this. Wait, that's. Oh, okay. Scott Messerschmidt. That's the phone number, though. That's not the login information. Jesus. Has it started yet? Hold on, because Baker is on, and I don't want to restream Baker on. Baker is restreaming Tom CPU. Let me call the court. Hold on. It's a different case, so hang on. The clerk there is just lovely. Okay. I don't need to email Baker because all I did was I just called the court. So we're good. We're good. It's courtroom 1, right? Hang on. Just have to wait for them to let me in. So anybody who's on the Zoom, please mute. Because what happens is if you don't mute, they hear me, and then I get in trouble. Okay. All good. His hearing has not yet started, so we are all good. Yeah, the court does it on purpose. They keep moving it around. It's not in courtroom 1. Okay, well, that's that is exactly Judge Doolin's courtroom for today. That is what the clerk just told me. I also had courtroom 25. Who's boots on the ground there? Up, and they had not yet started it. Okay, I will try courtroom 25 as well. Because that's what I had up before, remember? And it didn't start. Courtroom 25 is still waiting to start the meeting. So now I have both. I have both. Look, I'm in courtroom 25, which did not start yet. I'm in courtroom 1, which is what the clerk told me. That's where Judge Doolin is right now. It's in courtroom 1, says my paralegal, the Zoom was on, but it stopped because Aidan's case isn't on yet. Okay, so we have them both up. We're covered all around. I know that it's live on Broken Baker now. I'm aware of that. But he's restreaming Tom's CPU's stream because he's already in the Zoom room. And so when they let me in, we will be there too. Okay? Is that okay with everybody? Because if we restream Baker's stream, then we are going to be listening to Baker's commentary instead of my commentary, and I can't talk over him. So we're just gonna wait, okay? The membership is in the body of the description of the video. The description of the video. Okay. They will let me in. They will. Just didn't start yet. Thank you, Priscilla, for being here for 3 months. I love your takes and snark with these cases. Thank you. Thank you very much. You made mistakes in your email. If you know, you know. Gifted 5 memberships. Welcome to the new 5. Thank you, Kelly, for thanking me for hanging out for 7 months. And Lady Zelda gifted 5, so that's at least 10 today. It's at least 10. His hearing has not started yet. There are several other cases on the calendar, and they probably turned off, or they probably just aren't letting other people in until, as such, those other cases are over for the privacy of the others that are in the courtroom. Thank you very much. Lady Zelda and Kristen, thank you for thanking me. Thank you so much. There are a lot of supporters. Are there a lot of supporters in the courtroom today? It's in the big courtroom then, yeah? Because the calendar originally had it in the small courtroom where Karen Reed's case was tried. Okay, well, unless they let me in, there's not a lot I can do here. Hang on a second. Let me in. Let me in. Let me in. Maybe they don't want me to do it. All right, I can try one more place. Yeah, Stephanie, the one that you sent me, that's the one that I'm in. That's courtroom 1. That's the one I'm already in. I'm in courtroom 1. Can you guys see the screen? Do I have that screen up? Hold on, because I'm on a different screen. It's on 25. It's on 1. Try. I was in 25 also. Listen, if you guys want to go watch it somewhere else, you're more than welcome to, but that's not helpful to me. Here, I'll put this on for you. Hold on. I got it.
Through?
Yeah, go ahead.
Thank you.
Thanks,
Your
Tom
Honor,
CPU.
We're back here on discovery issues that have been going on. As you know, the automatic discovery certainly is due at or before the pretrial conference, which was like over a year ago. And we've been going back and forth with this. And if you just peruse the docket, I'm not going to go through it because I know these kind of tedious discovery hearings are awful for everybody. But if you peruse the docket, you'll see all kinds of motions to compel. Yeah, sure.
I think better I was on Zoom.
Yeah. Yeah, go ahead, Mr.
Yeah,
President. I'm
thank
sorry,
you.
I left my notes. I took some notes.
No, that's
while
okay. I appreciate you taking.
Yeah, and then I left it in the lobby. So.
We're willing to wait for you, Your Honor.
No, Mr. Summers went to get it. Takes good care of me.
Now I have the Zoom. You want the
Mr.
Zoom?
President. Go ahead.
So it's been like 9 months and we don't have the redacted extraction that the Commonwealth promised me. I look back at my emails on July 9th, 2024, saying it would be ready for pickup. And it just never happened. So now they are apparently doing a 180 in their filing saying, go get it from your friends, Mr. Kearney. And I don't really understand that. I don't think it's a serious response. And the Commonwealth owes us the discovery, the redacted discovery. And I ask that you order that forthwith.
Okay, let me hear from Mr. Cosgrove on that.
I can't interrupt because I have no ability to pause, so. we'll
Many
talk
of
about it
these
after.
issues, Your Honor, I addressed in my filing. I have been working diligently to get Mr. Bradel the discovery, despite some obstacles. If Your Honor would be kind enough to go through the list that you just went through with Mr. Bradel one by one, I will respond to them individually.
Yeah. The Commonwealth video of the rolling rally.
All right. The Commonwealth has provided at least 2 copies of the video to the rolling rally, one of them in the format specifically requested by Mr. Kearney. The last time it was provided was, I think, about 6 months ago. The first I heard that he was having a problem with it was the motion that he filed on the last date. As I indicated to Your Honor in my filing, I had notified Mr. Bradel of dates that he could come over to the office and we would attempt to show him the video and resolve that, which was his suggestion in the first place.
Oh, yeah, I remember reading.
And I got no response.
Mr. Bradel, when are you going to go over to see Mr. Cosgrove and look at this?
So Judge, that's a separate category, okay? I don't think, you know.
Let me start with this. When are you going to go over to Mr.
Yeah,
Cosgrove?
we'll be happy to go over it. We know we're not concerned with that aspect of it. We're concerned with the stuff that they were supposed to give us. We can put that aside, the stuff that they tried to give us.
Right.
And it didn't work, you know, that it's not the right format. Nobody can open it short of Bill Gates. And, you know, that stuff, I'm confident with our team, there's some really good computer people on our team that can figure it out. And we've said to them, just do this, and they haven't done that. So if we have to go over there, fine.
Mr. Cosgrove has said to you, come to the office.
Yeah.
We'll do it.
Yeah, we will, and that's not what this hearing is about as far as we're concerned. There's a ton of other stuff
Okay,
that doesn't require that.
that's fine. Go ahead, Mr. Cosgrove.
And the second item, Your Honor?
Let's see. I have the Brady list.
I had indicated to Mr. Bradel that I would provide that information 30 days before evidentiary hearing or trial, whichever came first.
I think, and then you said you'd give it to him by September 3rd in your memo?
Yes.
I'll order that. I'll order you to give it to him by September 3rd. So that takes care of that.
What's next, Your Honor?
Okay. Let's see. We have, I think we get to then the, supposedly somebody working as a government agent.
Oh, that would be
Kate Peter.
Catherine Peter, I believe.
Yeah. All right. So tell me about that.
Well,
Yeah.
Catherine Peter is relevant basically to the Lindsey Gaetani cases. She is a former employee, as I understand it, of
You don't know?
Mr. Kearney. He and she had a falling out over issues that don't concern the Commonwealth long before this case was originated, and basically exchanged negative posts about one another. From time to time, she has emailed usually Lieutenant Tully.
No, I'm not interested in the specifics, but more so, I think in your filing that I have in front of me, you have replaced the defective thumb drive. Am I correct?
Yes.
Mr. Bradel, do you have that?
We do, Judge.
All right, so then that's taken care of.
Yes.
All right, great. All right, that's good. Provide.
Yes, sir.
Okay. So then we go to the next one, which is a digital copy of all communications from District Attorney Morrissey to civilian witnesses. And it gives a list of names. And then it says that from Mr. Bradel's point of view, that the Commonwealth hasn't provided complete discovery. Go right ahead, Mr. Cosgrove.
Well, I don't know what he thinks he's missing, number one. Number two, what the Commonwealth is obligated to do under the rule is to provide statements of witnesses.
Yeah.
It's not obligated to provide the electronic information which may accompany it, any more than when it turns over a photograph. It's required to provide who the photographer was, that sort of information. I think this information, I have an inquiry in, would be difficult to access and provide. The Commonwealth has spent literally days assembling statements of witnesses, which are voluminous because it includes all kinds of emails that the witnesses have made to the district attorney's office. And those have been harvested by means of electronic system called ETOS by using term searches. And then people have gone through them and screened them, and I have screened them for compliance with Rule 14, generously construed, and those have been turned over. I can conceive of certain situations where electronic information might be exculpatory, and I think that's an issue that can be raised on a email by email basis. For example, if it were, if you had an email from somebody and their location at the time that they sent the email undid or provided an alibi or something like that, that would be exculpatory. It should be turned over. But in the ordinary course, all this does is provide information to the defendant that is irrelevant and is not required to be turned over. I think these are issues that can wait
How much longer should we
for a
wait?
determination as we approach trial as to whether something is material and admissible.
Okay. Mr. Bradle, can you comment on that?
Yes, Judge. So this is the metadata issue?
This is the individual, well, it's a digital copy of all communications from District Attorney Morrissey to civilian witnesses,
Oh, yes. Okay. Thank you, Your Honor.
and it lists a whole slew of people.
Sure. So, Judge, the Commonwealth in this case has been going to the mattresses, so to speak, to keep this stuff from us. And meanwhile, the employer of the special prosecutor has released a FOIA of these items, which, just to move ahead for a sec, the fact that they released all this stuff pretty much obliterates this Commonwealth's impoundment privacy argument. But while we've been going back and forth with all this court time with keeping things secret from the defense here, the district attorney's office released 4,000 text messages from Trooper Tully as a FOIA request to the general public, while we, as defendants in a criminal matter with constitutional rights attached, have got nothing. So it's out there, this FOIA request from the employer of the special prosecutor, but not from this special prosecutor. So in terms of the integrity of this stuff, we need the special prosecutor here to give us the items in the context of this case.
The 4,000 text messages, were they
Yes.
related to this case, Mr. Bradle, or related to other cases?
Well, it's relevant to the Reed matter, to our matter, it's all the same alleged victims. It's actually emails, not text messages.
Okay.
But it's 4,000 pages of stuff that we've been wrangling back and forth about. Meanwhile, the district attorney's office releases them in a FOIA like a week ago. That has been bandied all over media while we've been trying to get this stuff for a long time.
Okay, let me
So
go to
it's,
Mr.
yes, it's a good thing that we're getting it,
Yeah,
but we need the government in this case to give us what they are contending is that stuff.
let me just go to Mr. Cosgrove for a minute. Mr. Cosgrove, were you aware of that?
The short answer is no.
Yeah,
It's, I guess, part of the price of having an independent special prosecutor, Your Honor. I don't work out of the office. I haven't been to the office within the last 2 weeks, I think. So I was not aware of that. I was aware that 12 news
Everybody knows.
organizations had filed FOIA requests for information in the Karen Reed case,
sure.
but I wasn't aware of what particularly had been released. I'll look into that.
Okay.
I will say that when Mr. Bradle says he's received nothing, that is flatly untrue.
Okay. I remember the last time we were here, Mr. Cosgrove, you had said that there were 5,000 pages, or some large amount of pages. I'm not going to say 5, it might have been 3.
It was about 5,000. I think it was 4,700 and something.
Okay. Was some of that blank, or?
Well, the only information I have with respect to that was a letter from Mr. Bedrow that arrived 5 days later complaining that the bulk of those pages were blank. I do not know why they would be. I haven't been able to figure out why they would be. As a result of that letter, I went back to the DA's office and sat down with one of their electronics people and had them make an entire new copy off of my laptop. And I actually added a little material that had come in since provided by one of the prosecutors in the Reed case, but the bulk of it was the same 5,000 pages. I then went through that personally with the electronics person sitting by my side and ensured that each and every page was reproduced on the copy that I sent to the defendant. So,
have you sent that to Mr. Bradle or Mr. Betterow?
I've sent it to Mr. Bradle, and I'm informed that he's got it, so I'm not quite sure why we're still talking about it.
Got it.
Got it?
Got it yesterday, Judge.
All right.
So haven't been able to go fully through it.
Yeah, no, sure.
It supports all sorts of other things that we're here for as well.
All right, but you did get it, okay.
Yes.
All right, then the next thing would be, the next thing I see, and Mr. Bradle didn't think this was much of an issue, was the video of the Commonwealth surveillance from the rolling rally. Has that been?
I think we addressed that, Your Honor.
We can go to the office, and I'm sure that.
Yeah, okay, so that's fine. So that takes care of that, that's good.
Thank you.
And then,
okay. Judge, before we move on, I don't want you to go too far off of this. So I know it's tempting to think that these 4,000 blank pages is the same thing as the 4,000 FOIA. They're different. So the first thumb drive thing with the 4,000 blank pages has been remedied, okay? But the FOIA thing that should have been given to us has never been given to us, but they're responding to FOIAs about it to everybody but Mr. Kearney. So
I get that, but Mr. Cosgrove says he's gonna look into that, and I'm sure he'll give it to you.
Okay, so I just didn't want you to think that was the same.
No,
4,000.
No, I
Coincidentally,
didn't
it's different.
Yeah, I didn't think that.
Okay.
All right, I didn't think that. All right, then I think it's just am I correct, Mr. Bradle? Is that the list, or are there more?
There is more, Judge.
Yeah, tell me the rest.
All
Go
right,
ahead.
sure. So within the thumb drive, the thumb drive that was just remedied and given to us, there's all sorts of attachments, and we have a disagreement about this. There's all sorts of attachments from Ms. Peter to the state trooper team and Mr. Mello, I believe it was. I don't think Mr. Cosgrove was on the case then, where Ms. Peter is repeatedly providing attachments of things to the state troopers, and she's literally working on videos for the state troopers that were exhibits in the grand jury.
Let me just hold on for a second.
Yep.
Mr. Cosgrove, is that part of the 5,000 pages?
Yes.
All right, so then there, you got it at least.
I wish I could say we did have it.
Yeah.
If you hit the attachment, you get that message saying nothing's there. I printed out a few of them, but I'm sure you can just take my word for it, Judge. It says no attachment, nothing found, et cetera, et cetera. They don't come up.
So that's a technical issue. I'm sure you can figure that out.
So I think it's worse. I think it's it's actually a lot. Sorry, Judge.
I drove it again. He says you are good to go.
Yes. All right. I'll see you shortly.
Okay.
Thank you very much. See you in a minute. Thanks. Bye.
Bye-bye.
Bye.
Saying goodbye to the
Your Honor, it's actually,
Wonders of Zoom.
yeah, it's actually a lost evidence issue, Your Honor. It's not a, oh, gee, we can't open it issue.
Yeah.
It's gone. I think they lost the evidence. And for whatever reason, the attachment has been taken away on the other end, okay? So this is a real bit of prejudice and a distinct bit of harm to the defense that Ms. Peter, who is a government agent, who's provided, and we'll get to this.
Let me just ask Mr. Cosgrove before you go into all of that.
Sure.
Mr. Cosgrove, to the best of your knowledge, has that been turned over to Mr. Bradle and Mr. Betterow?
Has what been turned over?
Has any of the attachments that Mr. Bradle has just referred to?
Depending on what the attachment is, some of the attachments are visible simply by clicking on it. Others that specifically Mr. Betterow has inquired about, to the extent that I can resurrect them, I have sent them along to him and will continue to do that. I haven't worked my way entirely through his letter. But what happened, Your Honor, is this. Lieutenant Tully, who was the recipient of most of these, has the practice of not clicking on unsolicited links that are sent to him on email.
They were
So he doesn't
solicited.
access them. Now, if someone is sending him a reference to something that is online, he may check with that person and ask the person, where can I find it online? And then he will go himself and look for it online. For example, Mr. Kearney's YouTube presentations that were introduced to the grand jury. All of those
YouTube presentations
were things that Lieutenant Tully found himself online. He may have been pointed to them by Ms. Peter. He may have been pointed to them by one of the alleged victims who complained about them. May have been pointed to them by multiple sources. But he never clicked on whatever it was that was sent, in part because he's working off a computer system, an office computer system, and there's caution about infecting it with unsolicited links. So these were never accessed, in effect, by the Commonwealth. If the links are now dead, we've never seen them. The links are dead presumably because whoever sent them took them off the internet. So
This would be some text from somebody with a link to a video or
Videos
something else.
that Kate
And
Peter
so you'd have
was
the text,
making.
but not what the attachment is?
you'd have the text, you'd have a link to a video.
I get it, okay.
You click on the link now and
Yeah.
nothing happens. Whether if Lieutenant Tully had clicked on the link
Right.
6 months or a year or 18 months, it would have taken him somewhere. Probably would, but he didn't.
Okay, gotcha.
Taking him to
All right.
Narnia. Where's Chaka
Mr. Bradle.
in the land of lost
Go
people?
ahead.
Bit of a red herring to kind of suggest that, oh, some crazy person from the internet is sending me something and I don't want to look at it. That's not this. This is a government agent, Catherine Peter, sending them stuff that she's working with them. And you know, you mentioned an evidentiary hearing the other day, Judge. I think we should have an evidentiary hearing on this discovery stuff. Let's bring in Mrs. Peter and let's find this stuff, because this is important stuff, and I'll tell you why in a second. But this isn't some unknown person. This is someone who repeatedly emails the state police and Mr. Mello, so in other words, and the government and the prosecution and the Commonwealth, and is actively assisting the Commonwealth, providing links to certain things. So they're gone. And so let me just jump ahead. One of the things that's missing is Ms. Peter, and we know this from the new emails that we got last night. Ms. Peter changed the titles of Mr. Kearney's shows that were these 4-hour shows, Your Honor, that had innocent titles, like, you know, for example, Karen Reed case, where's Michael Proctor? Amiri King wants to fight Turtleboy, Canton updates, Anti-Bev Canoni out of control. So it's a title that encapsulates a 4-hour show. That was his work. Ms. Peter changed those titles, provided it to the Commonwealth, told Lieutenant Tully in the emails that we have about changing the titles, so they knew. And then they put those titles in as exhibits. We found this out, of course, after the McCarthy-Odell motion. And these titles are different. These titles are very incriminatory, and they suggest they impact Mr. Kearney's alleged intent to intimidate witnesses. The titles were all changed, and I can proffer up a spreadsheet of the actual titles and then what she changed them to in these attachments that, oh, gee, now we can't open them. So do the math on that, if I may approach, Your Honor.
Yeah, sure. Thanks, John.
We knew
And
this.
so we have now learned that we have a grand jury that was listening to these video clips with titles like, you know, I'm going to kick Colin Albert's ass. And that's just me paraphrasing, but nasty titles. Give me another copy of this one. Yeah. Trying to destroy Colin's life. The actual title is Commonwealth Tells More Lies About John O'Keefe's GPS Data.
Right.
That's his real title. And these were suggested to be Mr. Kearney's expressions, which of course would be used as his bad intent. And they're false and they're lies, and they were done, and we know this from the emails, from this Catherine Peter person.
Yeah, but so what does this have to do with?
So these are attachments that we can't open. There's an example of attachments that are exculpatory and incriminatory to the Commonwealth that we can't even open. So
these YouTube, so on the side of the document where it has the link, your allegation is
Right.
that you can't open up any of these.
No, I'm sorry. That's if you wanted to see for yourself. But the other two columns are what Ms. Peter made those titles.
Yeah, no, I get that.
And then the regular
Yeah, no,
title.
she changed.
Yeah, and that was
This
used,
document, she changes.
that was published to the grand jury as Mr. Kearney's work. And it was even argued in Mr. Cosgrove's, one of his recent filings, he argued that, about how these things are so aptly titled, is what he wrote. You may remember that. And this is all false evidence.
Okay.
So, you know, this
They're
is,
looking for us to do with it, though.
I'm looking to ask to take you up on your offer to have a hearing on an evidentiary hearing where we bring these people in and we get to the bottom of how Ms. Peters' work for the Commonwealth went. And that also impacts, and see, this is all interrelated, Judge. We want Attorney Mello on the stand for this too, because he's the one that presented this false evidence
File a motion
to the grand
for all
jury.
this. I'll take a look at whatever you file, but I think we're kind of getting off track a little bit in terms of what the
Yep.
Commonwealth owes you. That's what I'm concerned.
Okay, I know, I hear what you're saying on that
Yeah.
issue, but we did file a motion to disqualify Mello, who's been, you know, not able allegedly to be here, but he can be on Zoom. Whenever there's a hearing where Mr. Kearney's bail might get revoked, he's right on the Zoom watching. But, you know, that's another thing we'd like to do here today is ask the court to schedule an evidentiary hearing on
Gotta write a motion.
No, we did, Judge, I filed two.
For an evidentiary hearing? Is it a new one?
Yes, on motion to disqualify. We have two pending. In fact, Judge Rayburn, I believe it was, set the hearing, and he alleged that he was sick and couldn't come, and it's been in abeyance forever. So we have, Judge. I don't want to, you know, bury the court.
talk to you, Mr. Cosgrove. Sure.
Sidebar. This is fun, isn't it? So apparently they dumped a whole bunch of discovery last night on the defense, as always. And many of the things that Kate Peter sent to Tully were not able to be accessed because the links just went nowhere. Cosgrove doesn't seem to think it's important. I don't think the judge is understanding the importance of it. We do, because we've been here for a long time. They also say that with regard to the Kate Peter emails and the Lindsey Gaetani case, that they've replaced that thumb drive, that 4,000 pages were blank. Cosgrove doesn't think that Morrissey's emails need to be turned over. He doesn't think he's obligated to turn them over. That they should be gone through one by one.
So you see, Judge, how everything's interrelated. And with respect to the disqualification issue, this is another issue where Mello's involved in this, what we would contend is a conspiracy to put false evidence in front of the grand jury that we figured out. And it was used and argued, it was a misrepresentation of Mr. Kearney's intent. Because when you would put a title like that on something.
So this is what I'm trying to get you back to, though, Mr.
All right, go ahead, Judge.
Is what do you need? What else do you say that Mr. Cosgrove has as the special prosecutor that he hasn't turned over to you? We went through that list of items. I just want to get you back on track.
Sure, okay. So Judge, there's a November 1st email that we can't get the links off of that. And that's important. If I could just have one moment.
Yeah.
That might be the one with the video, that she attached a video. She changed the names.
That's the exact email with the links to this, the fake links to this that we can't open. And it's not a thing like, it's not a thing where, oh, well, let's go back to the office and fix it. It literally says, Google Docs, it says, sorry, the file you have requested does not exist. So it's gone.
Okay.
So why did this person make it go away? And I think we know why, but that's why I want to ask you for that hearing too. But, so we want the government to, in writing, tell us what links they have and what links, where did they go? We want them to respond in writing to why there's lost evidence.
Okay, let me just talk to Mr.
They have what we have, and they can figure out where they went to the same extent that the Commonwealth can. The Commonwealth has not deleted any links.
All right, I'll take that under advisement. What else you got?
It says, Judge, literally, the files have been deleted.
Okay.
It doesn't say they've been deleted by the Commonwealth.
So would the court consider ordering the Commonwealth to, we'll tell them what links we can't open, and they need to give some sort of an explanation why this is lost evidence.
Why don't you give us a list of the links that can't be opened?
All right, thank you.
And send it to Mr. Cosgrove. And Mr. Cosgrove, I just ask perhaps if you give us an explanation as to why they can't be opened.
Sure, I will give you an explanation. I will consult with our experts,
Yeah.
but I can almost guarantee, Your Honor, that the explanation is going to be that whoever is at the other end of the link removes the content.
That very well might be it, but I think it would, if it was in writing, it would probably be the best.
Yeah, I'm happy to do that, Your Honor.
That's great. What else, Mr. Brady? What else?
So, Judge, we talked about the Gaetani redacted extraction, excuse me. So can I get a copy of that? We don't have it. We've been looking for it for 9 months. Can you order?
What is it, the redacted?
The redacted extraction.
Okay.
Of her phone.
But you had the document at one point in time.
We had it. Judge Krupp ordered us to destroy it and give it back, which we did.
Yeah.
And just 9 months ago, we never got it back.
The redaction back.
Right.
Okay. Mr. Cosgrove.
I object.
Okay.
Because Lindsey Gaetani filed a motion that we just read.
Well, there's a long history on this, Your Honor, and I went into it in one of my memoranda at length. In the original course, the Commonwealth and the defense entered into an agreement that they would return the original extraction and that we would provide them with a redacted version limited to those things that we felt they were entitled to under Rule 14. I asked Lieutenant Tully to prepare that. He did that. I sent Mr. Bradle a notice. I don't recall when, but the date is in my memorandum saying it's available at the office. Come over, pick it up, or let us know how you want to get it. And I believe I also indicated that there was some additional material on the thumb drive with that extraction. Mr. Bradle never picked it up. In the meantime, came back to court for various reasons that are, I believe, still presently impounded, although I believe Mr. Kearney referred to them on one of his YouTube shows. For various reasons, Mr. Bradle indicated that he needed to keep the original thumb drive. Those reasons were unrelated to any issues in this case, but I was persuaded that he should be able to do that at least temporarily. We struck an agreement with respect to the use of that thumb drive, and there was a subsequent reduction of that or a modification of that to writing at Mr. Bradle's request that was endorsed by the court. And then in the Commonwealth's view, which the defense I believe, still disputes, Mr. Kearney immediately went out and violated those restrictions. So I then filed a motion in front of Judge Krupp requesting an order that the thumb drive be returned. Now, at that point, Your Honor, the defense had the full unredacted thumb drive in its possession, custody, and control for some 9 months. Mr. Kearney had publicly stated on his YouTube presentations that he had provided the contents, a duplicate of the contents of that thumb drive to any number of other people. But the physical thumb drive was ordered returned by Judge Krupp, and it was returned. In the meantime, the defendant had been presenting what I would consider to be various material irrelevant to the case, designed to embarrass and humiliate Ms. Gaetani. There was a reference, for example, to her DoorDash orders. There was the defendant picking out a phone number more or less at random and said, well, here's a number that she apparently calls a lot. Let's see who this is, and calling out the number live and dialing it live on his YouTube show. There was a reference to her ex-husband's daughters, if I have it correctly, and what they thought of Ms. Gaetani, so forth and so on. Judge Krupp allowed that motion at a provision that I agreed to, but I think was initially suggested by Mr. Bradel. The defense was allowed 2 weeks before they turned the thumb drive over, or approximately that amount, to take notes on anything they thought was relevant on the thumb drive, and then it was returned. As far as I'm concerned, they had it. They had an opportunity to examine it. I assume they did examine it. If they have time to go into the kind of trivia and side roads that Mr. Kearney went on to. I don't think at this point that the Commonwealth has an obligation to jump through further hoops and re-provide them with a different version.
All right, I'll take that under advisement.
May I be heard on that, Judge?
I think you already were. But I'll give you 30 seconds. Go ahead.
Yeah, Judge, there's no violation. If there was a violation by my client, I say bring it on. There's never been an allegation of a violation. If there was a violation, you know this Commonwealth would have done something about it. There was never a violation. They agreed to give it back. We don't have it. We were allowed to take note of it, but we were ordered by Judge Krupp to destroy it and not have any of it until we got the redacted one back.
Let me ask you this. Did you have it for 9 months?
Yes.
Thereabouts?
Yes.
Did you have a chance to look at it?
Yes, we looked at it, but we were told to destroy it. We don't have any evidence from it. It's destroyed. We were told, ordered by Judge Krupp to destroy it. We need another copy of it. We need the extracted copy of it.
You need the redacted copy.
Hey, we're happy to take the redacted copy,
That's
of course.
fine. All right, under advisement.
All
What
right,
else you
thank
got, Mr. Bradel?
Judge, so you just have one moment, please.
Yeah, no, take your time.
He's gathering his thoughts.
Judge, impoundment. As I alluded to earlier, the fact that the sovereign of the special prosecutor here has already released much of the items that government here is trying to keep private, I think it's completely.
Are these impounded or under a protective order?
Judge, I would say that I don't think it matters, Judge.
I think legally it does, doesn't it?
Well, it's a similar examination, Judge. Okay, it's a protective order. Things are impounded by either a judicial order keeping judicial documents private, or you could say, and I think the parlance is that if something is under a protective order, it's impounded from view from people.
Right.
So I think it's just sort of a parlance issue. I think frankly, the government was splitting hairs when it was trying to say
But
that.
you have all the documents, right? Everything that's under a protective order, you have as Mr. Kearney's lawyer.
Judge, we have the documents that are under protective order, because as I alluded to last time, you know, we're sort of under the gun of having to agree to it to get them, and we need these documents. So at the time, but this is a serious deprivation of the public's rights to know, Judge. The public is the victim here. And, you know, these are documents that are kept private for no good reason. Whether it's, you want to call it an impoundment or a protective order, there's no legal basis for it, Your Honor. As I said last time, things that show government malfeasance.
What's the basis for a protective order, though? We were discussing that today. Do you have any case law that you could point to on exactly what it is that the government, the hoops that they have to jump through to get a protective order?
Judge, I filed 8 pages on it last time.
Yeah, but what's the, give me some of the cases that you think are the most important. Because that was actually something we were working on today, trying to.
Well, Judge, the first order of business on that is that the burden's on the Commonwealth here.
Yeah, no, I agree.
So,
I agree.
you know,
Maybe I should ask that question to Mr. Cosgrove.
Please do.
But I'll ask it to you first, and then I'll go to Mr. Cosgrove, because the burden is on the Commonwealth. I agree with that. But these protective orders are already in place. So I understand you have the constitutional argument that you and Mr. Betterow have profit about the public's right to know. I get that part. But just in terms of a practical.
Thank you.
Yeah.
1 second, please, Your Honor.
Yeah. No, take your time.
Laura Velazzi says, motion to return these guys to the memory care unit. I heard they might be
So,
on.
Judge, paragraph 3 of my filing last time, Aidan Kearney's motion to release case documents from impoundment. Paragraph 3, New England Internet Cafe, LLC versus Clerk of Superior Court, Suffolk County, 462 Mass 76. Public has a right of access to judicial documents and a right to understand and observe the operation and work of the judicial branch. They're presumptively public documents. There's a common law right of access to judicial records. So that's sort of that's where we start, is that these records need to be in the public's view. And so the burden is on the government to say why. And then just to carry through, just going to allude to what I said last time, is that when there's corruption or malfeasance, embarrassment, that's not a reason to hide documents from the public. That's a reason to show the documents to the public of the government's missteps. And in this case, there's been a lot of them. And that's really what the government is saying, like, oh, we can't have Mr. Proctor's emails because there's a safety issue. You know, there's always a safety issue. It's either children or a safety issue. There's no safety issue. There's no children involved. It's just embarrassment. He's well on record to show all sorts of horrible things that he's said in his texts or emails or wherever. But, and so the idea that we're going to hide any more of it is ridiculous. And the other issue, Judge, is that of the ones that we get, there's never the full story. There's like one screenshot of someone's text, and then there's no responses. There's no, you know, there's just a one little thing that they hope we're going to look at and be satisfied with. There's never any context to this stuff. So that's another discovery aspect.
Let me just give the floor to Mr. Cosgrove then about the protective orders. I agree with your filings, Mr. Cosgrove, that these are protective orders as opposed to impounded. So I'll start with that.
All right, Your Honor, and let me just say, as I previously indicated, the release of certain public records is new to me. If Mr. Bradel wants to go through the public records that were released and compare them with the material that is presently under protective order and identify any of those particular things, I'm happy to assent to their release from the protective order, because obviously if they're out there, they're out there, and the protective order isn't really serving any purpose as to those particular materials. Now, with that said, in terms of cases, Your Honor, I would direct Your Honor's attention to the case law in particular cited on page 2 and 3 of my brief that talks about the validity of discovery orders in terms of discovery protective orders as opposed to things that are actually documents filed with the court. I think that's the pertinent case law to direct you to.
Okay.
I would also, Your Honor, like to direct you, if I could, to a YouTube presentation, which is essentially a commentary on the opposition I filed. Mr. Kearney did about an hour and 10 minutes of his own commentary on my filing. It's in YouTube episode 795, entitled, and I'll leave it to the defense to correct me if I get the title wrong, Cosgrove Gets Frisky, What Happened on the Cape, Twitter Shenanigans. And if you start at about 141 at that presentation, and if you can stand it, Your Honor, follow through to about 350, you'll hear Mr. Kearney's explanation as to what he wants these matters released for. I would characterize his comments somewhat tendentiously as saying, apart from some quibbles about whether I got the titles of his YouTube shows correctly, Mr. Kearney's response is, everything Cosgrove says I want to do with these documents is exactly what I want to do, and so what?
Okay.
Well, Judge, if you look at my filing, there's about 35 cases in there that talk about all this stuff dead on point. And there's no Turtleboy exception to the First Amendment, okay? Everybody out there has got this stuff, and Mr. Kearney is not allowed to look at it or use it. It's ridiculous. Every journalist on Twitter is citing this stuff, and he's got to sit here. The guy that broke half of the stuff in the Karen Reed case, he's got to sit here and not touch it and not do anything. It's ridiculous. It's totally abhorrent. And
so these 400 things that were released on the FOIA request.
4,000.
4,000. Oh.
Those are Marcy's private emails.
Do you have a copy of those?
Everybody's got a copy of those.
Yeah.
I don't have a copy, Your Honor, but I assume I could get it.
I'm not surprised.
All right. Perhaps, I know it's voluminous, but...
we can give you a link, Judge. It's easy. It's nothing.
Okay.
You like a link?
Yeah, that's fine. If you could just maybe write it out.
No problem.
All right. Do we have anything else?
We do, Judge. I'm sorry.
What else we got?
Spot here today.
I just would like to make one more submission.
Yeah, go right ahead.
With respect to the issue that we're on. One of the points that I made, Your Honor, in my memorandum is that there's a cycle here, which is that Mr. Kearney continues to post things about the witnesses in his case and the Karen Reed case on a regular basis. That provokes typically the witnesses to complain to the district attorney's office. That generates statements which need to be turned over in discovery. And I made the point that turning over much of this material, I don't know what public interest there is, for example, in an email where someone says she received an anonymous threatening phone call, which she attributes to a Kearney post, whether rightly or wrongly, other than to, I just don't know what the public interest is in that kind of thing. The public does not have an interest in going through everybody's cell phone, underwear drawer, et cetera, et cetera. Just to drive home the point that Mr. Kearney is continuing on a almost daily basis to publish tendentious commentary about these people, I want to call to your Honor's attention something that came to my attention this morning that he posted 24 hours ago. If I could.
Yeah, let me take a look at it.
Here we go. Aperture bought copies of John's underwear. Yes, they did.
Oh, yes, they
He
did.
missed a few of his usual targets, but most of them are there. I'm not suggesting that this is a violation. I'm not suggesting that it's criminally actionable.
Somebody give the judge some readers. He needs some readers. Look how close he's to that paper.
I am suggesting that it would help Your Honor conceptualize the use that he's going to make to any of this material that's under protective order.
Give him anything because he'll talk about it. Because Massachusetts is where your constitutional rights go to die. Does anybody have grave concerns for your constitutional rights in Massachusetts? Anyone? Anyone? Bueller?
Okay. I looked at it. I get the point.
All right, that's all I have, Your Honor.
All right. Mr. Brito, what else you got?
Judge, I can, just watching you peruse Mr. Kearney's publications, okay? Thomas Paine, Samuel Adams, Mark Twain would be spinning in their graves if they saw that a judge was looking at First Amendment protected satire, jokes, criticism, as if there's some risk that this stuff should be sanctionable. It's just completely antithetical to the First Amendment, Your Honor.
Okay, I don't want Mark Twain to feel poorly about me.
Really.
So,
Judge, it's just ridiculous that the government,
The laugh track.
proffers that as some sort of evidence of something is just completely beyond the pale. Okay, this is all First Amendment protected.
I get your point. I get your point.
So
You've made it very well.
So there's a few more things, Judge, about this impounding these.
The impoundment I get. So I get your arguments on that.
One little
Do you have
fact.
any other discovery issues?
Yes.
What else
Can
you
I
got?
give you one quick fact?
Yeah.
These people that the government is trying to protect with these impoundment orders that they need or protective orders, they're doing interviews. The McCabe, the Alberts, Proctor, they've all done nationwide interviews. And yet the government wants to say, oh, we need to protect them from safety because of keep their stuff private. They're doing interviews. So that ship has sailed, Your Honor. All of their stuff needs to be unimpounded for our use, for our ability to use it without these constraints, and for the public's right to know, Judge. It just needs to be out there. There's no reason to keep it.
No, I get your point. All right. Is there any other pieces of discovery that
Yes, Judge.
that you want to argue about? Because I have, I got some other things we have to do, some other cases. We have 2 other cases left. Mr. Bradle, I don't want to rush you, but
Just
go ahead.
going back to the Mello issue, Judge. So Prosecutor Mello was the one that was working with Ms. Peter on these phony clips. And we need his emails too on this stuff. And I hope you're not going to say, oh, okay, file a Rule 17. Because I did that with respect to Morrissey's emails. And I was told by Judge Krupp, and I think it's the law of the case now, that no, that's a Rule 14 issue because it's in the possession of the prosecuting authority. So it should be Rule 14 discovery that Mello is communicating with Kate Peter, and it's been undisputed and it's been revealed in this case 100% that Mello's been talking on the phone with the other complainant here, Gaetani, and we have only incomplete screenshots and inconsistent screenshots with respect to what's on the phones versus what really happened. And we need a written explanation from the government as to why there's inconsistencies in the discovery, and I'll tell you what that is in a second. But also, we need the full text report. We have these cherry-picked little texts. And like I said before, it's obvious that it was a string, and we get like one email with no responses or no prior context. And it's like they're hoping we just go away as they give us one thing. But it's not, the context isn't there, the full email strings aren't there. And we've made this complaint many times and it doesn't go anywhere. So I'd ask that you order the Commonwealth to either give us the stuff or respond in writing why they can't find it, don't know what I'm talking about, or whatever their position's going to be.
These are the mellow emails you're talking about?
So we want mellow emails because he's talking directly to Gaetani and Peter.
Yeah.
And we have a couple snippets of them, but it's clear there's other ones from the context that we don't have.
All right, I got you.
Yep, thank you.
All right, Mr. Cosgrove.
Well, I believe I turned over the Mello emails in the last round of discovery, and that generated a chiding letter from Mr. Betterow saying that you've had these for a couple of months now. We should have got them sooner. So I'm not, so far as I know, they have the Mello emails.
Right.
Okay. That being said, I think we should pick another date.
So Judge, just the last thing on that. If I
Yeah, no, go ahead.
Sorry.
No, go
Just
ahead. That's fine.
For example, Judge, there's a very important group text between Morrissey, Proctor, Tully, and others. And we have like one email from it that points up an extremely provocative issue relative to Proctor saying, why don't we just arrest him about my client?
Oh,
And there's no other discovery on it.
why don't we just arrest him?
There's a perfect example of cherry picking, why we need answers on this stuff. We need more. And there's also, Judge, there's inconsistencies in what we were given, where
Morrissey,
there'll be,
Proctor, and
here's
Tully?
my last thing. Well, there's a list of text messages from discovery that we've been given. And then online, Ms. Peter, it's related to this Ms. Peter again, she publishes a string of text. It's the same string, and there's more emails, or text rather, there's more text in her string that she published online than in the discovery we got. So it's kind of a smoking gun that something was taken out of the discovery we got out of an extraction. And sure enough, we checked with Celebrate, the extractor has that ability to unclick a box to deprive the recipient of something, and the recipient has no idea. So there's a smoking gun here, Judge, that's why this isn't a normal case. I don't think you've ever heard me talking this deep about getting discovery. And here we are because of real reasons, Your Honor. And I hope that the court can give us this relief.
Okay.
Thank you.
All right.
Something funny, Judge?
Why don't we pick a date or anything further that you might have?
Does the court want to suggest a date? I haven't had too much luck suggesting dates myself lately.
You don't have any other jobs, sir. You came out of retirement for this shit show.
So, Judge, in the meantime, would the court order production of some of those written responses? And
Yeah, I'll issue an order on the written responses.
thank you.
I'm sorry, what written response?
I think he's asked you to give written responses as to, for instance, the links and things like that, which can be open, what can't.
Oh, yes. Well, I just indicate that Your Honor indicated that Mr. Breda was going to provide me with a list that I would respond to, so I would just hope your order would take that into account.
Fair enough, Mr. Cosgrove, fair enough.
And Judge, just to the suggestion that, we should tell him what links we can't open. We can't open a single link. There you go. Compliance.
So, all right. Give me a date that works for the both of you.
September
24th, 25th?
I can't do the 25th.
What's going on? Nothing. You got nothing. You're
24th is
retired.
fine.
Okay, that'll be at 2 p.m.
We'll see you on September 24th at 2.
Mr. Kearney, your cases are continued to September 24th at 2 p.m. for further discovery.
Okay, thank you all.
Thank you.
Freaking waste of time. What has been solved today? Nothing. Bradle ain't playing.
I know, I was going to say the first one, the prior.
Hot mic, Tim. Hot mic.
Yeah. We go.
We get 88 cooks.
Like, that's what he means. It's so, it's so ridiculous. That, like,
Hot mic, Tim. Hot mic.
Okay. Well, we also need,
that he would cite that as some sort of problem. She can.
or Ethan.
There's boots on the ground with a camera outside the courthouse that's going to catch them coming out of the courtroom. I mean, coming out of the building.
Can't be Colin.
Anyone? Colon, can't be colon. I'm here for the hot mics. Thank you, Generous Gigi, for your 5. I appreciate you so much. I'm here for all the hot mics. Where are my boots on the ground? Do you guys have cameras outside the courtroom? Or are you going to catch them coming out down the steps? Cold Hard Ground says I was charged and had a non-suggestive ID done with the witness. It cleared me, so the Commonwealth lost it. Thank you very much for your time. It's horrible what happened to you.
Number 3. Commonwealth versus Abdul Magasa, 22 CR 252. Mr. Magasa is.
All right, it's a different case that we are not here for. I'm probably going to shut the Zoom down. Wow, just wow. Aaron says, I don't know about this judge. Your thoughts on him? And I mean, he seems to think it's funny. He knows how ridiculous it is. And he seems to, hopefully he's going to order an evidentiary hearing. So that's what I think, Aaron. What do you guys think? This is going on for way too long. They've had this discovery since at least December of last year. So we're going on 8 months and then some. It does violate all of his constitutional rights. And listen, if they took, which we believe is true because we know, because if you watched Turtleboy the other night, he pulled up some of his episodes in which they renamed them something like Colin Albert is something, and it had nothing to do with Colin Albert. Kate Peter, if it's true that she renamed all of those streams and that was presented to the grand jury as being titles of his shows, that's all false evidence that was entered into the grand jury to indict him. That could be egregious governmental misconduct. How many motions do they have to make about that exact issue? And so I don't know if he's going to do the right thing. I don't know if he's going to do the right thing, Aaron. I don't know. And I also don't know if he's going to be the judge for long because he keeps switching judges over there. Judge Krupp ordered that initial order. And now it's Judge Doolin. Who knows how long he's going to be there for? Kurt Smith says the corruption is such a mess. Even the judge has lost track. Right. Thanks for your 5. Cap Rising. My state's judicial system has been a circus forever. Remember the 1692 Salem witch trials? Yeah. They're still here. They're still ongoing. Karen Reed, they wanted to stone her in town square before they hung her because she was a witch. She was a witch. Anna says, shouldn't Cosgrove and this judge be in a balcony somewhere insulting the Muppets? Thank you. You made mistakes in your email. If you know, you know. Says, relax, Judge. Aidan is only facing 105 years in prison. That's right. That's right. For those of you who don't know, he is facing 105 years in prison for the selective prosecution of this witness intimidation statute in Massachusetts, which basically says if you hurt someone's feelings and they are a witness or maybe a witness or a family member of a witness in a proceeding, you can be charged with a felony. Thank you for your 5 and for reminding me that that's why we're really here. That and, the First Amendment. And Moira Valesi says Cosgrove thinks the First Amendment was written by Miss Manners. Thank you. Hang tight. Yeah, I don't know why Lindsey Gaetani didn't have to make any oral argument. I don't know. Justice served as in Linda Kenny's channel. No, Tom CPU. All right. We got to go to Tom because we always go to Tom. We always go to Tom CPU. He's our guy. Oh, and you know what? I can rewind this a little bit. Aidan is outside the courthouse, so just hold tight. Shout out to Tom CPU. Give him a love. Give him some love and a like and a sub.
He said to us on the way out, he said,
Problem is that the audio is not great and it's a little crackly. So let's rewind it a little teeny bit. It's because, I don't know, is there any actual media, like real media trucks there sucking up the signal?
This soccer, Tully, Buchanan, Morrissey, And these are public servants. These are outlandish messages. We can't show them to the public. They're in our motion to dismiss. We have to redact them. We can't even mention them in open court, what Proctor's saying. It's the nexus of where my charges came from. And their response to our request to unimpound them is, I shit you not, Ratchet Madness. Did they vote? Did they vote? In which?
Wait, so Ratchet Madness is what he showed the judge privately that we couldn't see that he was looking at? Wow. Wow.
In which the printout from this publication shows that one of the matchups, for those of you unfamiliar, it's a thing where total riders vote on who was the most ratchet of them all. And in the handout he gave us, Robert Cosgrove. Hey! Robert Cosgrove. So he hands the judge a document and says, this document is mocking me. Therefore, the public doesn't have a right to read Michael Proctor's text messages because I'm embarrassed. And inside, he said to us on the way out, he said, jokingly, I told everybody to vote for me. He thinks it's a big joke. This is funny for him. And he's actually saying, no, but we're all in danger. The whole public's in danger.
Cosgrove said, I told everybody to vote for me. And that's what he gave the judge. This Ratchet Madness competition that Aidan has about guessing who the biggest ratchet of the year was. And Cosgrove is in there. And it embarrasses him, but apparently not, because he said, I want everyone to vote for me. And that's what he gave the judge.
Children are in danger. We release these matters of public concern messages because of Ratchet Madness. That's the best. It's pathetic. And I think Judge Doolin is getting the message. I think he's done with this. This is a joke.
It sounds like you're just spinning your wheels and they're asking for the same thing over and over and over.
Yeah, I was saying, Aidan, it's the nature of these discovery disputes. It's like watching paint dry. Who wants to listen? I can't even stand listening to myself. It's just awful. And they're supposed to just give this stuff up willingly. They're supposed to go out of their way to make sure we have all this stuff. And it's just, I can't believe he was saying that, even after they agreed to give us the extracted redaction, they're like, oh, we changed our mind and, forget it. It's just insane. It's an insane, unserious response. So what we're trying to fight here, guys, is the Turtleboy exception to the First Amendment. You guys can use all these these FOIA requests. And, you guys can have them and talk about them, but, the guy that's behind, everything, why we're here, he can't talk to me. We can't talk about it. We can't use it. It's ridiculous.
Here's what's frustrated to me. If I practiced in this jurisdiction, I'd be in jail. Because you have the Commonwealth dicking around with the material, but then you have a judge who won't do anything about it.
Well, Judge Doolin, we are happy that Judge Doolin is looking at this case. And, the old saw, the wheels of justice move slowly, but it's going to come around. We're going to be okay. It is frustrating. We know he's going to do the right thing, okay? He's trying to be respectful to Mr. Cosgrove, but I think that, that bank account is dwindling, and it's gonna go south real soon. And we're going to get all this stuff, and we're going to be able to freely use this stuff. And when we do, fasten your seatbelts.
What are you hoping for on that September date? What's the next?
We want everything unimpounded. We want all the attachments or an explanation why, because we contend that constitutes lost evidence. And when the Commonwealth loses evidence, the Commonwealth's in trouble.
We want Mello, K. Peter, and Brian Tully on the stands. We want to know. I was indicted for witness intimidation based on videos that were presented to the grand jury with names that I did not give those videos. One of the videos they presented, video 616, is going to destroy Colin Albert's life. That's what they named the video. The actual name of the video was something to the effect of exposing corruption in the Commonwealth. You're sitting on that grand jury and you hear exposing corruption of the Commonwealth. You're thinking, well, geez, this guy must be doing something good. But when you hear the title of the video is going to destroy Colin Albert's life, you might think this guy's a bad guy. They literally lied to the jury. And the question is, who changed the titles of those videos? And there's only one person out there who's sick enough to watch every single thing that I do and lie about it. Because we know Cosgrove mentioned one of my YouTube presentations in there the other night. We know he didn't watch it because it's past his bedtime. Somebody sent him that video with that exact timestamp and gave it to him, and he presented it in court. He's not doing any of this work. It's being sent to him. He doesn't know the first thing about what I'm actually about. He'd probably like me. To be perfectly honest, he probably like me, as most people do. But instead, he's just collecting his paycheck and going through the motions and declaring war on the First Amendment while he triple dips off his pensions.
So let's hear the evidence you're hearing. You got close to getting that, and so then there was a sidebar, and then Cosgrove didn't want you up there. So what happened
It
with
was
that?
the judge's idea. He said, let's have an evidentiary hearing and bring them all in. I said, let's do it. Let's go. Bring it on.
And
so,
you he doesn't want to do it.
We're gonna get the written response pretty soon, and let's see what we got. But it is slow, but I think we're gonna get somewhere with all the stuff. We're gonna have the unimpounded stuff. We're gonna have the attachments. We're gonna have the text messages. You know, people going on national television can't scream, can't cry and hide behind the Commonwealth protective orders. It's coming out. It's coming.
How will you know? How can you be sure you're getting everything after all of this?
Well, that's a great question, Michelle. It's a leap of faith. There's always in the end, there's always a leap of faith. So you have to kind of try to go behind what they give you and look at it and say, you heard me up there saying that, like, the context doesn't make sense. They gave us one text message on this huge incendiary topic and no responses, no prior, no after, no nothing. So that's a smoking gun to us that there's more, that they were hoping, I think they were hoping we would be satisfied with this one thing and go away, and when we know the juicy stuff is still to be given, and we're not going to stop till we get it.
And like you said, sometimes they inadvertently show us that they haven't given us stuff. They gave us what they claimed was our complete redacted or complete cell phone records, except she sends a whole bunch of messages to Kate Peter that are not returned from Kate Peter, that just her. And then Kate Peter goes ahead and shares screenshots on her YouTube presentations showing the other side of those messages, which are gone.
I didn't get.
And conveniently, those messages start disappearing the moment Brian Tully becomes the topic of conversation. So the gatekeeper, the guy who gave us this stuff, the messages about him are all gone. Just about Brian Tully. What a coincidence that is. But we're just supposed to trust Brian Tully, who completely disgraced himself with the Karen Reed investigation, who decided that I should be in jail after I started calling him out for his corruption, came to my house and read me my rights in my driveway. That's who we're supposed to trust. No, thank you.
At his kids'
Do you
bus
think
stop.
Kate Peter's ego would allow her to delete permanently these YouTube videos, these links that are not accessible anymore? Do you think she still has them somewhere?
She said, if you couldn't hear, do you think Kate Peter's ego would allow her to delete these YouTube videos? Do you think she still has them somewhere? That's a great question. I don't know who asked it, but it's great. Sorry about the audio, but the Wi-Fi outside the courthouse really stinks. They just got Wi-Fi before the first Karen Reed trial in that courthouse.
That's not my, I have a law degree, not a tech degree. So that's why I count on people like Courtney and, computer people that, figure this stuff out for us. I don't know. I mean, the links Aidan pointed out in the middle of the hearing, it literally says this link was deleted. So, but that's on the Commonwealth. It's lost evidence.
But I thought they said that they were Google Docs and not YouTube presentations. I thought they said Google Docs.
They had it and they let it go bye-bye because Kate Peter is part of the Commonwealth as far as we're concerned here. And they had it, they let it disappear. And that's a big problem for them. And that's our next battlefront is lost evidence. We're going to be addressing.
Could you be seeking sanctions or another motion to dismiss based on that?
So it's hard to seek sanctions. The sanction would be that they can't use the evidence, but we want the evidence. It's going to be exculpatory. We know that. So, we have to go right to dismissal, which of course is a drastic remedy. But how much longer are we going to deal with this stuff? They have to give us the stuff that shows this conspiracy, that shows how they're trying to trample on the First Amendment, that shows they're falsifying evidence for the grand jury. And this stuff has to come out, and it will come out, and we're not going to rest until it is out, and we're going to use it to move to dismiss this case.
Were you surprised at the big dump from yesterday? It's kind of poo-pooed by the court. They're like, oh, you got it now. You're good.
You can take that one.
He said big
Clever I did that.
Yeah, I mean, we don't know that it's poo-pooed. He's taking it all under advisement, so we'll find out in when he rules on this, whether or not he's actually poo-pooing it. If he allows our motion, then You know, hopefully he's taking it more seriously. I hope he's starting to get the picture here about what's going on. This is not an honest prosecution. It's not a serious prosecution. I was arrested, almost 2 years ago? What progress has been made on this case? What do we do? What, we come here every once or 2 months and we go through this motion where we talk about all the stuff they haven't given us, and then we go home, we eat our cheese sandwich, and we go to bed, right? But nothing ever gets done, ever. And I think that's how they want it. I think they just want me out on bail. So I'm on thin ice, so I have to be careful about what I say and who I talk to, etc. It's a joke. It needs to end, and hopefully it ends at least by this time next November when Michael Morrison's voted out of office and these charges are finally dropped. This is a joke.
Do you believe that the court and Cosgrove really didn't know that the FOIA request was complied with, and there's an overlap with the impounded material? They oh, I don't know. I've never heard of that.
No, I don't know. I don't know what he reads every day. I don't know. It's kind of hard to miss it if you're on social media.
I guess everybody's got it but us and Cosgrove.
This is not mainstream media. This is Tom CPU's YouTube presentation. And his audio is not great, but nobody else is live streaming this right now. So you get what you get and you don't get upset. So they used to tell my kids in preschool. This is what it is.
Yeah.
Can you guys tell us what's in there?
If Kate was an agent, does that mean all her communications are now discoverable?
Good question.
They do have a work product privilege where they can talk strategy about things, but anything that's exculpatory has to be given over. Anything that shows an investigator bias or a compromise to the integrity of the investigation has to be turned over.
All right. Thank you guys for coming.
Thanks, guys.
Shout out to Tom CPU. Give him a like. Seeking justice. Tommy CPU. Boston Mike. A lot of people there. All right, let me give you this again. Hold on. A lot of supporters outside the courthouse. Mute the audio, but you can see how many people are there. It's pretty. That's a good turnout for a Wednesday afternoon. Hey. All the regulars, all the usual suspects. I find it interesting that they didn't ask Lindsey Gaetani for any oral argument. That motion that she wrote, pretty good. Well done, Tom CPU. Thank you so much for letting me restream. As always, you're the greatest. Well, if you're just joining, let me recap for you after I look at a couple super chats. Nurse of interest, thank you so much, Jackie, for your 10. Says Dean, she's calling me the Dean. You should invite Cosgrove for a reading circle time. Great coverage. Do you think he would come? Do you think he would come? Apparently, he's happy that he's involved in Ratchet Madness. So that's interesting. He told everyone to vote for him. That's funny. Thank you very much for your 10. Josh. Between this case, King, Walsh, and all the others, the Norfolk County District Attorney's Office has serious issues with providing discovery in cases. I think that's why Doolin is laughing. I think you might be right. Thanks for your super chat, Josh. As always, Jenny Jen, welcome. Became a member. Hashtag journalism is not a crime, says Just Irish. Thank you. Karen D says, why are grand juries legal? I don't know what you mean. Grand juries are always one-sided. They're secret proceedings. But in this case, if they did show fraudulent evidence to the grand jury, it just could overturn the indictments and or have the charges dismissed and or entitle Aidan Kearney to a very, very big Section 1983 claim against the Commonwealth and the district attorney or special prosecutor Mello. Ms. Lily, thank you so much for becoming a member. Amanda, so glad I figured out my super chat finally. Thank you. Thank you, Anne, for your matcha latte. Kraft Haskell says, can't they write a motion to dismiss based on fraudulent information presented to the grand jury and then destroyed? Thank you so much. They already did a motion to dismiss. We went over it. Then we read the decision. 6 of the felonies were dismissed. But again, it's motion after motion after motion because they are not turning over the discovery that they have. They're not turning over the discovery that he's entitled to. And it's BS. They keep kicking the can down the road every single time. And it's always a different judge. And it's infuriating. I'm not surprised that he's infuriated because I'm infuriated too. And we are all outraged. Love my flip flop says the Commonwealth loves to spend innocent people's money. Ain't that the truth? Patriotiac, who is an excellent researcher, says the links are inactive because apparently whoever once uploaded them to Google Docs subsequently removed the document from that URL, i.e., the hosting site. Thank you for that, because that's what apparently happened. There was a bunch of things that were attached to text messages or emails, and then when Bradel went to click on them, they are gone. They are no longer active links. Another argument Bradel made is, why can't we get Marcy's emails? Because the public has them, because people got over 4,000 pages from just a FOIA request. We know, because we went over the emails the other day, and Cosgrove played dumb and said, I have no idea what you're talking about. I don't know what you're doing. What are we doing here? I have no idea. I didn't know anything about that. How could he not? Does he live under a rock? It's rhetorical. Shannon's, thank you for your 20, says, Melanie, can't Kate Peter get in trouble for changing the titles of these videos? Yeah. That's tampering with evidence. And if she provided that evidence to Ken Mello to get her nemesis, Aidan Kearney, the guy she hates the most in the world, indicted, that's tampering with evidence. And if Mello didn't do his due diligence and actually look up and make sure that those were the actual titles of the actual videos, they got a problem too, because the buck stops with them, really. Kate Peter altered evidence, and then they used it to indict him. I mean, that's rough. People are asking what Ratchet Madness is. Cat's Meow looked it up. Cat's Meow 420 and says a ratchet is someone or something considered trashy, low class, or uncouth. To be honest, I didn't know what a ratchet was either. I had to look it up in Urban Dictionary myself. I'm like, what's a ratchet? I'm old. I don't understand what these expressions mean all the time. Then also apparently Kate Peter was working on videos that were presented to the grand jury, not just changing the names, but they can't be opened because, again, the allegation is they were destroyed. The links are no longer active. Bradel called Kate Peter a government agent. And Cosgrove did say, when the judge said, can you produce those links? He said, well, to the extent that I can resurrect them, which was an interesting choice of words. And then his excuse for that was, well, you know, Brian Tully doesn't click on unsolicited links. So he probably just looked them up himself. And he, you know, because there's a warning not to click on unsolicited links. And Bradel's like, yeah, but they're not unsolicited because she's providing him information to provide to the grand jury to indict Aidan Kearney, the man she hates most in the world. So they were not unsolicited. Apparently, she's a not so confidential informant who may or may not have been paid by the Commonwealth, which is fine. But if she was, you got to disclose it. Bradel wants an evidentiary hearing, and so do we. He wants Mello on the stand. He wants Kate Peter on the stand. He wants all of them to get up on the stand. We want it too. Will Judge Doolin give it to him? I don't know. Soko Judy said earlier, Cosgrove is thinking, I need to retire. The funny thing is, Judy, he came out of retirement to handle this case. Where is Ken Mello? I need proof of life. I need proof of life on Ken Mello. Last time we saw him, I think, was on Zoom, and he had an oxygen tank. So I don't know what his medical condition is or if he's doing better or worse, but we need proof of life on Ken Mello. At one point, Bradel said, well, the judge said, after Bradel said he wants an evidentiary hearing, the judge was like, oh, well, file a motion for it. He's like, Judge, I filed like 5 motions for a hearing, like 5, and they're there. Do I need to file another one? And then he said that one of the text messages that they got shows a conspiracy to indict Aidan Kearney, that there was a group text message between Proctor, Marcy, and Tully that said, why don't we just arrest him? Why don't we just arrest him? Do you think they were trying to set him up? Do you think there's a conspiracy here? I do. That email with the links on it was apparently written on November 1st of 2024. None of those links can be opened. They want a redacted extraction of Lindsey Gaetani's phone because they were told by Judge Krupp they had to give it back and or destroy it, and which they did. Cosgrove objected to that. He woke up and he's like, I object. And so Bradel went on to say, well, the public is the victim here, Your Honor, because everything's been released pursuant to FOIA request. But that was about the Marcy emails, not the Lindsey Gaetani stuff. So I'm not really sure. My notes maybe a little bit out of order. And then there was an episode 795 of Turtleboys that Cosgrove said was entitled Cosgrove Gets Frisky. And the judge found that to be very amusing. And we all laughed. And then at one point, Bradel said, Sam Adams, Mark Twain, and somebody else are spinning in their graves right now. And then the judge said, well, I wouldn't want Mark Twain to feel bad. And everybody in the courtroom laughed. Bradel said, you cannot not release. I want to show you Cosgrove's response to all the things he didn't turn over quickly, because they're looking for, of course, Cosgrove filed this like today or yesterday. It's his response to the inventory of outstanding items. These are all the things they were discussing today. And number two, number one was the information relative to specific requests regarding Kate Peter as a government agent. No response from the Commonwealth. Cosgrove replies, information relative to Kate Peter was provided to the defense in the thumb drive delivered on July 7th. The defense later claimed that the bulk of pages in that discovery were blank, although obviously much, if not all, of the Kate Peter material was not, since the defense has referenced it in his subsequent demand for additional discovery. The Commonwealth has replaced the allegedly defective thumb drive and provided some additional Kate Peter discovery to the defendant in emails over the last week. Well, I don't think it was over the last week. I think it was like just last night. And he said, Bradel said, still, we can't open those links. Second thing was a digital copy of all communications from District Attorney Morrissey to civilian witnesses / alleged victims in the instant 2023 case, including Jennifer McCabe, Kerry Roberts, and any other such persons. Commonwealth has provided incomplete and piecemeal paper copies of such communication. Then Cosgrove's argument was that they're under a protective order and that they do not have any obligation to provide digital copies of any of that stuff. I don't think we got any of that stuff in the FOIA request. We read a lot of Marcy's emails. I've been through at least 3,000 pages of the 4,000 pages, and I didn't see any emails between Marcy and Jennifer McCabe or Kerry Roberts. Did anybody? Maybe I just didn't go through the whole entire thing yet. So this case has now been adjourned to, he also wants Mello's emails. But he said, all of these witnesses are doing interviews, Your Honor. Proctor, the McCabes, the Alberts. And so you can't say that their privacy rights are at issue here because they're all out there doing interviews. And he seemed to get it. The judge did. And he also said, Bradel, I also want Mello's emails because he was in cahoots. He didn't say cahoots. I said cahoots with Kate Peter. And he wants all those too. This case has been continued to September 24th, 2025 at 2 p.m. And the judge said, what are you looking for? And he said, I'm looking for an order. And I want all this stuff unimpounded. And I think the judge said he would take it under advisement, or he said we're going to discuss it again next time. But maybe you guys can tell me. A desire for civil discourse says that telling people to vote for him and then using it against Aidan, wouldn't that be some sort of violation, assuming it isn't a joke? I don't think so. I think it was said and just, but that's what a desire for civil discourse is suggesting. That was something I think they discussed sidebar, and then he gave the judge a copy of it to read at the bench. Like insane. It's insane. They've been given nothing. This case has been going on for over 2 years, right? Thank you, Anne, for your matcha latte. Thank you, Karen, for your Venmo. Says, I'm a resident of Massachusetts. I'm crying because we're used to this. Please help us. I'm crying right now. Don't cry. Don't cry. I mean, Aidan Kearney is the one who's going to expose it all. He's going to expose it all. And we're here for every minute of it. Somebody just sent me something, but I have to vet it before I can share it with you. So we'll do that. Thank you so much for hanging out with me today. Thoughts, questions, comments, concerns before we wrap this stream for today. Don't forget to hit the like button. Don't forget to subscribe because it's free. Don't forget to do all the things that YouTube likes. There's a motion on Brian Walsh that I would like to go over before tomorrow's hearing. So tomorrow, there's a hearing on Brian Walsh at 2. I think they're all coming back at 2 to talk about all the communications with Proctor that they haven't been able to get. But Larry Tipton was fired up and he wrote a motion to dismiss. He's like, enough is enough. You got to dismiss Brian Walsh's case because of all of the reasons that he sets forth in his motion and for all of the withholding of evidence and the abada. Brian Walsh has been in jail with that hammer haircut for, since 2023. It was 1 year after John O'Keefe, so it was 2023 for 2.5 years. He may be 100% guilty, but are his rights important at all? I don't know if Mark was on Zoom, Kathleen, because he didn't have his camera on. If he did, because the only box that came up for me was the judge. Thank you, Toasty Buns, for your 10. If the Commonwealth thought they had a solid case, they wouldn't have a problem turning over all the evidence. Corrupt to the core. Ain't that the truth? Ain't it? Aidan, is Aidan in the chat? Somebody just said hi to him. If you're in the chat and you want to come on, I'll send you a link. Oh, there he is. He says, that was fun. That was fun. It was fun for us too. It was fun that the judge was laughing. We're here for you. We're here for you. You look good. You guys look good. Your stylist is doing a bang up job, by the way. We're loving it. I did see Yuri's a karaoke gig. However, because there's music in it, I can't play it. Okay, Aidan says send the link. Hang tight. He may join us, so don't go anywhere. Hold, please. What a bunch of BS, huh? All right, we'll see if he comes on. If he's in an area with some service. Yeah, corrupt to the core. That's what a lot of people think, Toasty Buns. Thank you, 10. You're awesome. Thank you, Boston Girl, for gifting a membership. You're awesome, too. Here he is. The only. Daddy, what's up?
What's happening? How's it going?
I'm good. Can you hear me? I can hear you. Can you hear me? Can you hear me now?
Yeah, I can hear you. Can you hear me?
I can.
Okay. What'd you think?
Oh, I thought that it was entertaining. Not for you, probably, because this is enough bullshit that you've been dealing with for enough time. But it, the judge was laughing. All I could see on Zoom was him. All I could see was the judge. So he was laughing. He doesn't want to upset Mark Twain, and this is bullshit. Yeah. It's like kick the can down the road.
His argument for not keeping the messages impounded was Ratchet Madness. He actually handed that in as an exhibit. I couldn't believe it. And he handed it to the judge. And the judge is looking at this document that says Ratchet Madness on it, in which Cosgrove is a contestant. And then after court, Cosgrove comes over to us. He goes, I've been urging all my friends to vote for me. It's like a joke for him. But you are saying that these messages will be dangerous if they're unimpounded because of Ratchet Madness. This is just
right.
What country are we living in? This is banana land.
We're living in mass lighting Massachusetts, I feel like. Corruptachusetts, whatever you want to call it. But it's like, how much longer do you have to go through this? Because now you got to go back there in September.
Yeah, but you know what? It's like, whatever. Like, we want the evidentiary hearing. Like, it's worth it to get this evidentiary hearing where we put Tully, K. Peter, and Mello on the stand, and we get to the bottom of this. Like, we got a lot hashed out in court today about the problem here is that when I was indicted, they gave a lot of exhibits to the grand jury of videos from my YouTube presentations, and the videos were completely renamed. Like, they say episode 616, going to destroy Colin's life. That's what they claim the video is. The actual title to episode 616 is exposing Commonwealth corruption with GPS data or something like that.
Right.
It's like, so if you're on the grand jury and you hear the title of the video is exposing Commonwealth corruption, you think that, well, this guy must be exposing some sort of wrongdoing. But if you hear that the title of the video is going to destroy Colin's life, then
of course,
what does that sound like your intent is? And intent is all over the witness intimidation statute. It says that your intent must be to cause emotional harm with the intent that it will disrupt the court proceeding. So there you go. So they renamed it because they are masking what my intent actually is, which is to expose corruption, and making it seem like my intent is to harm and destroy Colin Albert's life.
Right. And if it was Kate Peter that changed the titles of all of those videos and provided them to Tully, who then gave them to Mello to present to the grand jury without doing their due diligence on correcting her mistakes, that's a big problem for all of them. For all of them, it's tampering with evidence. It's presenting false evidence to a grand jury. It is prosecutorial misconduct to the nth degree. And, you know, that should be enough to dismiss your indictments. But really, how many motions do you have to pay to be made before somebody finally gets it?
Yeah, and I'm hoping Judge Doolin gets it. I really hope, and I have faith in this guy, just based on his facial reactions today, laughing about this. It's like, what are we doing here? Who got hurt out of all this? Like, this is a superior court, you know, like other defendants are brought in chains, and you hear some of their things that they're being charged with, you know, serious violent offenses. Like, this is what this guy sees every day. And then I come in there and we're talking about Ratchet Madness. Like, this is an affront to the court of a place that's supposed to be a serious hall of justice in which serious victims are heard and serious facts are laid out in front of the court. And instead, we're talking about Ratchet Madness and somebody named Kate Peter and Lindsey Gaetani and these very unserious people. And over a criminal matter, a murder trial that was adjudicated 2 months ago and is over. There's no more witnesses to intimidate. It's over. Karen Reed was acquitted. What are we doing?
That's right. That's right. What about Bradel dropping the bombshell that there's a group message between Morrissey, Proctor, and Tully that said, why don't we just arrest him? Did I get that right? Was it Morrissey, Proctor, and Tully?
Yep. Morrissey, Proctor, Tully, Buchanan, and then 3 other small bubbles who were too small to read because it's a screenshot from an iPhone. So we didn't even get the report. So here's the order of this, right? In July, we've seen the Morrissey's emails. He contacts Attorney General Andrea Campbell's office and asks them to charge me with witness intimidation. They decline him, which he later bemoans in a December email in which he says, oh, she's going after these neo-Nazis, but she won't go after Turtleboy, right? So we know that she turns him down. Why does he want Andrea Campbell and the AGO to do it? Because it will give the appearance of bias if he goes after me. And he can't get her to do it, so he's like, fuck it, I'm going to do it anyway. And he goes, but something changes in those 3 months. So he asked them in July to charge me. I'm not charged until October. So what changes? Well, there is a group text message out there with all the big shots, and Michael Proctor's on it. We got a screenshot of it. And it's in our motion to dismiss, and it's impounded, but as Bradel said in court today, he gets mad. He gets real mad. Proctor calls me asshole. He doesn't call me terrible. He just calls me asshole.
Oh,
he's
really?
Very upset that I made a joke on my YouTube presentation about teaching his kids to throw a spiral football when he goes to jail. And this really upsets my. Proctor gets cranky. He starts putting things in writing on text messages, and he's like, "Why aren't we just arresting?"
Oh, he got cut off. Why aren't we just arresting him? because he got mad that Aidan told him, said that he would teach his kids how to throw a spiral football. I think he just went into a bad area. Jenny Jen says he does look fine in a suit. He's got a stylist now. And she's just doing a great job. And that was awesome. Here he's back. He's back. Hang on, because okay.
Yeah,
We
sorry
lost you
about
where you were saying, you were saying about throwing the spiral football. That's where you cut off.
Yeah,
About-
so I'm like making a joke about that, and Proctor got all mad about it, and he fires, he gets in the group text, and he's like, "Let's go arrest them. Why aren't we arresting them? We're the police. Why don't we do this?" And that text message is impounded, right? But Bradel mentioned
When was it? When was it sent?
Today. That can't be made to the public.
When was that
September
one
3rd,
sent? When?
2023. So a little over a month before I'm arrested.
September 2023. You're breaking up. September 2000.
September 3rd.
What?
That's right.
9323. And you were arrested in
September
October.
2023. Yes.
You were arrested in October, but you were let out on bail
Yes.
until the conspiracy to jail you, and then you were jailed, I think, on your birthday, right?
Yes.
The day after Christmas.
That's correct. That's right.
Wow. And then you did 60
right.
days, and then 3 days after you got out, that's the day they brought Lindsey Gaetani to court as a sword.
That's right.
To try and get you back
That's right.
in.
That's right.
Yeah.
I mean, it's just so transparently obvious what they're doing here, and it's all going to get aired out. They're trying to hide it. They don't want that group. In what world is a group text conversation between all the police investigators in my case not public information? And his reasoning for not, having that impounded was that Ratchet Madness. Like, that was literally his reason. He will make fun of these people. We're like, dude, are you kidding me right now? Like, it's my job. I talk about these people for a living. You make it more obvious what your goal is here, not to talk about this. And by the way, when Michael Proctor says that, we don't have any of their responses. He's with all the bigwigs. We just have a screenshot of an iPhone thing. We want the Cellbrite report. We want the whole conversation. Because what comes after that? Does Michael Morrissey say, okay, yeah, now we'll start getting going? And then yesterday we get more communications. They gave us those 4,000 missing pages we got last night at 10 a.m. I was up to 4 a.m. reading them all last night. I got, oh my God, my jaw was dropping reading this stuff. First of all, we got the Buchanan and Kate Peter messages. Those are juicy. And then they gave us, for some reason, all of Jennifer McCabe's text messages from January 29th, 2022 to February 2nd, 2022. And I was talking to Karen Reed about some of this stuff today. And she's never seen these. Like, some of these messages, like the communications between Allie McCabe and Jennifer McCabe on February 2nd are wild. The communications between Jennifer McCabe and Kaylee Furbush are wild. Like, it's like, it's a lot of stuff that Karen Reed
what was the date that Jen McCabe said she voluntarily gave over her phone?
February 2nd or 3rd, around that?
Because she said that she was allowed to delete all communications with her kids.
I got them. I got them all. I got all the communications.
Oh, I bet. And you're just chomping at the bit. I can see it. I'm chomping at the bit too. Hey, if you Venmo me $1, I'll be on retainer and I can help you look through all of them. And it'll all be confidential because I can't report on them either. Put me on the team, coach. Put me on the team, coach. Put me on the team.
I'm down for it.
When does
this end? Like, they don't want any of this coming out because they know how it's going to make them.
Well, you're breaking up on me, but it's going to be career ending for a lot of them if they if this stuff gets out.
Yeah.
Oh, you're breaking up on me again. Are you going to go live later?
This should be career ending.
Everybody wants to know.
Maybe. I'm going on Howie at 4:33.
Oh, well, I love Howie. Will you tell Howie I said hi? All right, you broke up on me. Just prepare for Howie. Everyone go to Howie Carr at 4:33. Do you know that I am in Howie Carr's intro? Hold on, because I'm going to show it to you because I heard it and I'm like, I think that's me. And then I was like, is that me? So I posted it for you guys to tell me if that was me, because sometimes, your own voice is like a little bit distorted and you're like, is that really me? So hang on a second. I'm going to play it for you. And you can tell me if you think that it's really me. 1 minute. Olivia, put me in, coach. Olivia's here. I saw Olivia in the chat. All right, here. Listen, and then I wrote something like to Howie. I was like, Howie. Oops. Howie, if that's me, I'll allow it, but you got to buy me dinner or something. And then he sent me a message, a little laughing message. All right. Wait, how do I play it for you? Hold, please. Oh. Wait, okay, here it is. Where's Melanie Little's left swipe in StreamYard? Because, you know, it happened. StreamYard really needs to up their game. I'm telling you. I'm telling you. All right, here it is. Tell me if this sounds like me.
I was referred to today as 1970s Boston.
It comes from the tabloid talk show.
Wait, it was before this. How do I rewind it?
Stuff in Boston, and it was concocted there.
The problem is I'm being confused by my own. That's like the screenshot of it. All right, wait a second. Let's refresh it. That always works. Ready, go. Go in a little Howie car, right?
Hey, paper boy.
Hold on, that was me. Hold on, I think. Ready, go. Nothing gets you going in the morning like a good cup of Joe and a little Howie car, right?
Hey, paper boy.
We love Howie Carr, right?
I was referred to today as 1970s Boston.
It comes from the tabloid talk show stuff in Boston, and it was
The tabloid talk show stuff. That was like Whitey Bulger's nemesis, right? Wasn't that me? It's totally me, right? He didn't ask me, but you know what? I'll allow it because I know he's a fan and he talks about me and he watches my show and he tells everybody to come watch my show. So thanks, Howie. I love it. So if you guys listen to Howie Carr at 4:33, you'll hear me again. And I suggest that you do. So go to, you can go to, I think, howiecarr.com and you can listen to it on the internet, on the interwebs. And I suggest that you do that to go support Aidan. Toasty Bun said if the Commonwealth thought they had a solid case, they wouldn't have a problem turning over all the evidence. Corrupt to the core. Thank you for your 10. Just saying, with Alicia became a member. Welcome. Boston Girl gifted a membership. Charissa, thank you. eBay, Warhol. Tracy Fagan said, Lady Zelda was right. Are you joining the defense team? I didn't know anything about that. Oh, that's really funny. Remember, she said, you and Betterell will do something together. I was really joking because I just really wanted to those text messages. So if you're just tuning in, Aidan Kearney said that they got the text messages between Buchanan and Kate Peter, and all of the messages between Jen McCabe from January 29, 22 to February 2nd, 22, between her and her kids, Allie, and other people. Tasha said the $1 retainer offer to go through Discovery just gave me Lady Zelda deja vu. I didn't even think of that. Did not even think of that. Thank you. Thank you, Tasha. And Beth Allen says, Howie Carr is on Rumble, the YouTube alternative. Melanie should stream there. No restrictions, no demonetization. I don't know anything about Rumble. I know I don't like Discord, but I don't know about Rumble. But would all of my followers come to Rumble? I mean, there was like 14,000 people in here at one point, or 14,000 of you are going to come to Rumble. I don't know. I don't know anything about Rumble. Thank you, Beth Ellen, for your super chat. And to all of my people. Yeah, that was Whitey Bulger's brother, Billy Bulger, that said tabloid journalism on Howie's intro. Yeah, so it's me, DJT, because I thought I heard him in there too, and Whitey Bulger's brother, Billy, introducing Howie Carr. Chaka rules. Rumble sucks. People say Rumble is lame unless you pay. All right. Jenny Jen will follow me anywhere. I love you with all of my heart. I'm going to see you soon. I'm going to die. But I'm going to see you soon. All the Goodmans are here. And Brian sent me a Venmo and said, great impromptu guest. Thanks, Melanie. The Goodmans. Thank you. He looks great today. And it's a shame to waste that outfit right? He's got to get on. It's too bad that Howie's only radio because, he's really dressed for TV today. And so I'm glad that he called in from his car, even though he did get cut off. And it was a great, Mandy says Rumble's better than YouTube. I don't know. Can you do both? Can you do both at the same time? Hi, Kelly Reed. Kelly Reed is here. Hi, Kelly Reed. All right. Oh, Rumble has really crappy people that are not allowed to stream on other sites, says Taylor. I'm glad he had a good turnout too. All right, everybody, go turn into Howie Carr. And I think maybe tomorrow what we'll do is go on early before the Brian Walsh hearing so that we can look at the motion to dismiss, or maybe I'll make it a separate show. So make sure you have all your notifications set. Make sure you have them enabled on your phone. Thank you to the moderators for keeping it classy because there's a lot of noise. There's a lot of noise out there on the socials from what I hear. I'm not going to get into it, but I heard there's a lot of people complaining about, me and other people like Aidan and Young Jerks and whatever on the cesspool of Twitter. And I don't really care, but don't believe everything you read on the internet. Stay cool, stay kind, stay classy, because I know you can do it. I know you can. And if I don't see you soon, I'm going to die. Thank you, mods. I love you.